Hey guys, while I don't share Nnamdi Kanu's lawyers, they don't let federal government of Nigeria know say this matter is not what they can take for granted anymore. This will not be choco. So they don't tell federal government of Nigeria how it is. And they don't still expose Nigerian government, deep secrets that Nigerians are not aware concerning this Mazi Nnamdi Kanu's case. Why they don't want to release Mazi Nnamdi Kanu, my people. This one will shock you. In fact, when I watch this video, I dey cry, I dey sweat. I was like, really? So all these things are really going on. And they are saying, make I just leave that one. Make I just leave this one. See, I want to say this thing again. And I've been saying this. If Nigerian government do not address this issue of agitations in the southeast, a time go come when we say the government of Nigeria no go feel timid. Anyway, guys, this is Prospect Channels TV. If you're just joining us for the first time, I beg subscribe to this channel, share this video, make it go viral, so that Nigerians will understand what is happening, especially Biafrans. Everybody will know what is happening concerning this Mazi Nnamdi Kanu's case. If you're just joining us for the first time, I beg subscribe, like us, drop your comment below the comment section. Let's just watch the video together. Thank you.
And wrote a strongly worded letter to the then president of Nigeria to retrace his steps and restore IPOB to its former legal status and cease and desist from further arresting or harassing or persecuting members of IPOB. Yet, from the date of issuance of that decision to when the former president left office, nothing was done. Rather, the opposite was done. The persecution, prosecution, arrest, torture, everything became even worse. It is pertinent to mention at this juncture, perhaps as a necessary digression, that had the former president of Nigeria implemented that directive issuing from the African Union, a lot of people who died numbering in the hundreds, some say in the thousands, and in fact, including Mazi Nnamdi Kanu's infamous extraordinary rendition from Kenya in 2021 wouldn't have happened. A lot of lives would have been saved and the nation would have been more at peace. And we will not have the insecurity that we are grappling with today in the Southeast. And further to the decision of the African Commission on Human and People's Rights, the United Nations, through its special rapporteurs, transmitted a decision in 2020, May precisely 2020, no, in October 2020, condemning the proscription, IPOB, and the terrorist tag placed on it. The quotations of what they said are contained in our press release, and they are verbose. But the summary of what they are saying is that the action of the federal government was driven by some ethnic considerations against the Igbo, and that the action offended every known canon of international human rights law. Consequently, this organ, which is a very important organ of the United Nations, directed the federal government to do the opposite by deproscribing IPOB. That the action was never taken to get that done, and so here we have it, that for quite some time now, these things have persisted, and here we are with the dramatis personae, this most single factor in this whole saga is Mazi Nnamdi Kanu, who remains in detention to this day under questionable circumstances. At this juncture, I will yield to my colleague to my right, Barrister Emeka Ejiofor, to take you through some of the analysis of what I have said. Thank you. Not Kanu, Prince Emmanuel Kanu. Yes, ladies and gentlemen of the press, what I said and what my two colleagues have said can be summarized as follows. One, you recall that Mazi Nnamdi Kanu's case was commenced almost over 9 years ago when he was first arrested in Lagos. Recall also that he was then charged with offenses relating to his broadcast on Radio Biafra from his location in London. You can imagine what it means for someone to be on an endless trial that never really happens for almost 10 years and being detained without conviction for 18 months, initially from 2015 to 2017, and again for over 3.5 years from 2021 to the present day. This alone is a gross injustice of its unique kind. 2, it's also to be recalled that after Nnamdi Kanu was freed on bail, Nigeria's army levied these lethal attacks against him that drove him into exile, involuntary exile, from which he was also renditioned in 2021. And recall the decision made in 2018 by the African Union that everything that has happened to the IPOB from 2017 to that very date, and of course much worse happened after. Recall that those things were declared illegal and unlawful and as having violated the African Charter at a continental scale. Now, also, the same action, in particular, the proscription of IPOB in 2017, provoked or triggered the rush of litigation that eventually culminated in the ruling of the High Court of Enugu State, declaring that such actions by the federal government of Nigeria against Nnamdi Kanu and IPOB are unconstitutional. So the question to ask is this: why is it that the IPOB, being of Igbo stock, it is not us as legal team making allegations? We have rulings of the international community. In the same vein, we have rulings of municipal courts in Nigeria indicating that what is happening to IPOB is nothing more than an ethnic-driven persecution. 3, now having survived the lethal attacks and having survived these many years in enforced exile and having undergone all these tribulations and travails and having been renditioned, these actions, this very action of the federal government of renditioning Nnamdi Kanu triggered the international legal order. In July 2022, the United Nations Human Rights Council came down with a gavel that Nnamdi Kanu was extraordinarily renditioned and that it was a violation of all canons of international law to which Nigeria is subject, and it recommended a generous compensation to be paid to him and cessation of his prosecution. That was ignored by the federal government. 4, it is noteworthy that on 29th June 2021, as indicated before, Nnamdi Kanu was arraigned, well, you can say produced in court, albeit secretly, through the back door and presented before Honorable Justice Binta Moritala Nyako, who was aware that Nnamdi Kanu had counsel of record. The prosecution was aware Nnamdi Kanu had counsel of record, not us, his former lawyers. And the DSS was aware of the information of his counsel of record. Everything was on file. Yet Nnamdi Kanu, or the court, conducted hearing over the head of Nnamdi Kanu and remanded him to DSS custody without notice to his counsel, not to talk of presence of his counsel. This is a flagrant violation of Section 36 of the Nigerian Constitution. 5, when you fast forward to October 2022, when the Court of Appeal discharged Nnamdi Kanu, there was also a judgment issuing from the Federal High Court sitting in Umuahia, which had declared his rendition from Kenya as unconstitutional. It didn't stop there. It went as far as declaring his continued detention in Abuja as unconstitutional. What will you do or expect a responsible government to do when the detention of her citizen is declared unconstitutional? You open the gates of the detention center and allow the citizen the free pass to go home. That's what Mazi Nnamdi Kanu deserved to have been done with him since October 2022 when that judgment came. But the federal government never did. That's part of the reason why we are saying his detention has turned extrajudicial and is no longer backed by any coroner. 6. Regarding the December 2023 judgment of the Supreme Court, which people are touting as having sent Mazi Nnamdi Kanu's case back to the High Court for trial, it doesn't end there. If it ends there, then it's a mischievous conclusion. The court went further. It said Mazi Nnamdi Kanu needs to go back to the High Court for trial, but it also said the High Court should not have revoked his bail. It also said that by revoking his bail, the impartiality of the High Court judge had become suspect. Ladies and gentlemen, you may not be lawyers, but when the apex court of the land tells a High Court, you should not have done this, what remains is for a High Court to do that which, or undo that wrong which he had done. And Section 287 of Nigerian Constitution backs this up, because under that section, all subordinate courts in the country, or all courts in the country, are subordinate to the decisions of the Supreme Court. It never happened. 7. Now, talking about the much vaunted trial of Mazi Nnamdi Kanu, we raised objections to this trial too, based on the conditions of his detention, which were very stringent and highly prejudicial to his right to fair trial. This application was summarily denied and an accelerated trial was ordered in its place. We raised a second objection based on certain constitutional infirmities and statutory issues we noticed in the charges facing against Mazi Nnamdi Kanu. This too was summarily denied. So if you were Mazi Nnamdi Kanu, what will you do under the circumstances? To succumb to a trial you knew in your heart to be going towards the trajectory of an unfair trial, or to seek alternatives to that. 8. Having considered those factors which we enunciated, Mazi Nnamdi Kanu felt that the only fair way out of this logjam is to seek that his case be handled by another judge. Hence, the recusal, the famous recusal that is still roiling the system. And in concluding this press statement, ladies and gentlemen of the media, we must go on record to say this. As lawyers, our duty is to ensure that Mazi Nnamdi Kanu's case is conducted or handled in accordance with all the laws pertinent to it, particularly the Constitution of the Federal Government of the Federal Republic of Nigeria, which is the ground norm. In our view, this has not been the case, and the evidence is legion, as all who have dispassionately followed the trajectories of this case would agree. On this score, ladies and gentlemen, we make bold to state that this case has turned from the legal and the judicial to the political. This is perhaps the reason why there is a broad spectrum of persons and organizations calling for a resolution of this case outside of the judicial part, also known as political solution by baptism. These calls range from the international to the domestic, including members of the Senate, House of Representatives, the clergy, CSOs, eminent lawyers, and many others too numerous to mention. Be that as it may, and judging from 2015 when this case began, 9 years ago, there is a trove of evidence that suggests that the only way to correctly describe what Mazi Nnamdi Kanu has passed through for almost a decade is to say that his case, even though bereft of merit from the very get-go, has turned from a trial to be conducted under the Constitution to a trial by ordeal. This is perverse and it will not stand. Thank you. This yes. If you okay, get whoever wants a soft copy right here. Otherwise, this is that we digress from this thing.
Okay, now I'll also stop here.
Huh?
To summarize. I'll also stop here.
You stop here. Then I may say summary. Don't start yet.
Thank you very much. My name is Nemeke Jofo. I am one of the lawyers to Mazi Nnamdi Kanu, who is currently under solitary detention at the State Security Service Headquarters, Abuja. To be clear, today, the 16th of January 2025, makes it well over 9 years that Mazi Nnamdi Kanu was arrested and detained on trumped-up charges of treasonable felony, publication of defamatory matters, and improper importation of goods into Nigeria. Mazi Nnamdi Kanu pleaded not guilty to the charges on the 12th of December 2015, but was remanded until the 25th day of April 2017, when he was granted bail, that is after 2 years of arraignment, even when the Constitution of the Federal Republic of Nigeria, Section 36 and subsection 5, presume all accused persons innocent until the accuser, being the Federal Government of Nigeria, proves such a person guilt. Even when Mazi Nnamdi Kanu was eventually granted bail, in spite of terrible and vehement opposition to the bail application, the Federal Government of Nigeria felt defeated and unsettled. Hence, devised a means to end the life of Mazi Nnamdi Kanu by its military operation in Afaruku in Dêêp, Abia State, the hometown of Mazi Nnamdi Kanu, codenamed Operation Python Dance, perpetrated between the 10th and the 14th of April 2027, where 28 persons were killed right in the compound of His Royal Highness, the Igwe of Afaruku, the family home of Mazi Nnamdi Kanu. Onyendu Mazi Nnamdi Kanu, by divine providence, was saved from being murdered in the process. His case came up thereafter before the trial court presided over by Justice Binta Inyako of the Federal High Court, Abuja, on the 26th of June 2018. But he was not in court, having exiled himself to Kenya to save his life from Operation Python Dance staged by the military. By Mazi Nnamdi Kanu's application to the African Charter on Human and People's Rights, he was granted provisional measures to ensure that he was not hurt by the Nigerian government, but that was never respected by the Federal Government of Nigeria. On the 28th of March 2019, the Federal Government of Nigeria lied to the court that Onyendu Mazi Nnamdi Kanu jumped bail and had violated the terms of his bail, and then applied for the revocation of Mazi Nnamdi Kanu's bail, the issuance of arrest warrant against him, and an order forfeiting the bail bond of his sureties. The court feigned ignorance of the fact that Mazi Nnamdi Kanu did not jump bail, but was forced into running away to save his life and physical well-being, and indeed granted the prayers of the Federal Republic of Nigeria, a move reprimanded by the Supreme Court. Following the order of the Federal High Court revoking Onyendu's bail and issuing a warrant of arrest, the Federal Government of Nigeria kidnapped and abducted Onyendu Mazi Nnamdi Kanu from Nairobi, Kenya to Nigeria in violation of Section 15 of the Extradition Act, therefore making it a trade now, a going trade in Nigeria, a very viable trade in Nigeria for kidnappers. And that is why we say that most of the kidnap we have today, they lent from the Federal Government of Nigeria. On the 29th of June 2021, the Federal Government of Nigeria produced Mazi Nnamdi Kanu in court, and in the absence of his lawyers, and without affording Mazi Nnamdi Kanu the right to fair hearing, ordered that he be remanded in custody of the State Security Service, those who went to kidnap him from Kenya. On the 21st of October 2021, the Federal Government of Nigeria amended the charges to add the offense of terrorism, and Mazi Nnamdi Kanu pleaded not guilty to the counts or charges. His bail was and remained revoked. Mazi Nnamdi Kanu filed a notice of preliminary objection challenging his prosecution in violation of the Extradition Act, contending that his prosecution on the counts that existed prior to his extradition extraordinary rendition was unconstitutional and abuse of court process and disclosed no offense known to law. The trial court agreed with Onyendu and struck out 8 out of the 15-count charge. On Onyendu, Mazen and Kanu's appeal to the Court of Appeal, the entirety of the outstanding count of charge were struck out for want of jurisdiction, and Onyendu was consequently discharged and acquitted on the 13th day of October 2022. In an unprecedented manner and against all known laws, both locally and internationally, the federal government of Nigeria refused to release Onyendu from detention facility, and on the 15th of October 2022, the federal government of Nigeria filed an application seeking a stay of the release of Mazen and Kanu from detention. This application was which is alien to Nigerian law and which never applies to cases of discharged and acquitted persons, was granted by the Court of Appeal, surprisingly, presided over by a panel of justices led by Justice Samani on the 28th of October 2022. Ladies and gentlemen of the press, it is a way and manner the case of Nnamdi Kanu is handled in a manner that no lawyer can explain, that agitates us, and we now ask, is Mazen and Kanu being prosecuted or persecuted? In an attempt to arrive at a veritable answer to the above question, we shall address some salient issues pertaining the way and manner Onyendu Mazen Nnamdi Kanu's case is handled by the federal government of Nigeria. The trial court, illegally and in compromise arrangement with the federal government of Nigeria, revoked Mazen Nnamdi Kanu's bail. Onyendu Mazen Nnamdi Kanu did not jump bail and was justified in running out of the country to save his life and physical well-being. This is the finding and decision of the Supreme Court of Nigeria at page 11 to 13 of the judgment of the Supreme Court in case number SC 1361/2022. According to Justice E.A. Agim of the Supreme Court, it was therefore wrong and malicious for the appellant that has caused the respondent to flee from his home and country to secure his life, and had therefore caused an unavoidable absence in court to inform and thereby deceive the trial court that the respondent jumped bail. On the basis of this deception, the appellant applied to the trial court for an order revoking the respondent's bail, forfeiting the amount securing his bail bond of his sureties, and an order issuing a bench warrant for his arrest. It is glaring from the record of proceeding in the trial court, and it is granted the said order in the trial court that it granted the said order prayed for by the appellant, with knowledge of the fact that the respondent's absence from the court was caused by the invasion of his home by army officers of the appellant. Therefore, the trial court knew that the said extrajudicial and illegal action of the appellant made it impossible for the respondent to be in court for his trial, and the respondent's absence is not intentional or deliberate absence, and that the respondent is not running from prosecution or running to avoid prosecution. The order was made in the false assumption that the respondent jumped bail. See page 10 to 13 of the Supreme Court judgment. Revocation of bail was predicated on the trial court's interest and bias. In this judgment, the Supreme Court is in clear terms condemned the trial court in revoking the bail of Onyendu Mazen Nnamdi Kanu. According to the Supreme Court, after it held that the circumstances of Onyendu Nnamdi Kanu's escape did not amount to jumping bail, it stated thus: in the light of the foregoing, the trial court acted unfairly and without rational and legal justifiable reason by its decision revoking the respondent's bail, forfeiting the amount securing the bail bond of his surety, and its order issuing a bench warrant for his arrest. This is referred to in page 12 to 13 of the Supreme Court judgment. At page 19 of the Supreme Court judgment, the Supreme Court unequivocally held thus: this indifference of the trial court to these unlawful attacks on the person of the respondent and the extreme violation of his fundamental rights while he was in custody of law pending trial rendered the impartiality of the trial judge suspect. Even when it was glaring that the said attack on the home and person of the respondent by the official of the appellant made his further attendance of his trial in the case impossible, the trial court, rather than found that he jumped bail, revoked that Hiddên bail, revoked his bail, and forfeited the bail bonds of his sureties, thereby victimizing the respondent. This is oppressive of the respondent and unfair to him. These are the wordings of the Supreme Court. The trial court ought to hold the federal government of Nigeria accountable for the absence of Onyendu in court and adjourn the case indefinitely until the federal government produces Onyendu in court instead of revoking his bail. It was the decision of the Supreme Court that the trial court did not do what the law expected the trial court to do in the circumstance where the federal government of Nigeria caused the absence of Onyendu in court by her Operation Python dance. According to the Supreme Court at page 19 and 20 of the judgment, it admonished in clear terms, thus, what the trial court should have done then was to hold the appellant responsible for the absence of the respondent, order the appellant to produce the respondent, and order a stay of proceeding till they produce him, instead of granting the appellant's application for the revocation of his bail, and order him to be arrested, and if he was running from prosecution, Onyendu was abducted and kidnapped from Kenya. The order of the trial court on the application of the prosecution was that the bail of Onyendu be revoked and the bench warrant issued for his arrest. In disregard of the procedure for arrest and renditioning of Onyendu who was in Kenya, the federal government of Nigeria unlawfully kidnapped and abducted him in violation of international laws and his fundamental human rights. According to the Supreme Court at page 20 of the judgment, I quote again, in purported execution of the unfairly obtained and illegal order of arrest of the respondent, the officials and agents of the appellant traced the respondent to Nairobi in Kenya, violated his fundamental rights, kidnapped, abducted, and extraordinarily renditioned him to Nigeria without any form of extradition proceedings, without the consent of Kenya, in complete violation of the Kenya Extradition Act and the Nigerian Extradition Act and the African Charter on Human and People's Rights Ratification Enforcement Act, CAP A9, Laws of the Federation of Nigeria 2024, and produced him in court on the 29th of June 2021.
So my question now is, what effort, is there any effort being made by the Kanu's family to get the president or the Nigerian government to agree to that council terms to that council?
Of them can do it.
Not what I'm saying. Any of them can do it.
Okay, good. Are you ready? 5. Most of silence. 4. Most of silence. 3. Everyone. I know what. Yeah. Everyone ready? Yeah. 5, 4, 3, 2, 1, go.
Good afternoon, ladies and gentlemen of the media, and welcome to this World Press Conference. Then we call them to zero in.
Okay.
So you can arrange for it.
Not clips, food.
Kanu. I proceed by saying that the undue delays in the hearing of Kanu is unprecedented. There is concerted effort by the federal government of Nigeria and the judiciary not to hear and determine Kanu's case and appeals on time. Instances abound. What we are saying is that normal cases we filed are usually taken. But when it comes to Nnamdi's case, it is different. On the 24th day of September 2024, Justice Nyako of the Federal High Court Abuja made an order recusing herself from the case of terrorism leveled against Nnamdi Kanu before her court, and sent the case file to the chief judge of the Federal High Court for reassignment to another judge of the court. It is getting to 5 months since the court made the order. There is no such reassignment by the chief judge to date. To the federal government of Nigeria, insofar as Nnamdi Kanu remains in DSS custody, trial can go to hell. Nnamdi Kanu has since the 23rd day of December 2024 written to the chief judge of the Federal High Court for a reassignment of the case, but to date, nothing has happened. On the part of the prosecution, no effort whatsoever is made for reassignment of the case to another judge. We all know how many judges are in the Federal High Court, Abuja, and who are eminently qualified and competent to hear the case on the merits. But then, it is either Justice Binta hears the case or Nnamdi Kanu languishes in the DSS detention facility indefinitely. So, in the decision of the federal government, it must be Nyako that must hear the case. If we insist that another judge will hear it, then he must remain in DSS detention facility illegally. All appeals against the task decisions of the court are never fixed for hearing, and every effort made by Mazi Nnamdi Kanu and his legal team to get dates for the hearing of the appeal is thwarted by the prosecution and the court of appeal. On the 26th day of September 2024, when the bail application appeal came up for hearing, Chief Awomolo SHAN applied for the consolidation of Mazi Nnamdi Kanu's 3 appeals so as to forestall the hearing of the bail restoration appeal. The application was by way of letter that was neither copied nor served on the counsel to Mazi Nnamdi Kanu, but then it must and was granted. Similarly, on the 8th day of October 2024, when parties were ready to adopt their processes in respect of the bail application, the panel of justice led by Joseph Olubimika Oyewole and S.S. Onwike, Justice of Court of Appeal, refused to hear the appeal on the purport that they needed time to study the appeal. That has never happened. All of us are lawyers. If you adopt your process in court, they have 3 months to study it and give their decision. But in this case, they say they want to study it before they can hear it. Now, till date, they are still studying the appeal, so that on the 17th day of October 2024, when the appeal came up for hearing, they discovered, in quote, that the decision of the trial court appealed against was only signed by the registrar of the court. And in spite of request for short date, they adjourned the appeal to the 13th day of January 2025. The legal team of Mazi Nnamdi Kanu applied for abridgment of time for the appeal, having secured the ruling in the manner desired by the panel. The application was ignored, and Mazi Nnamdi Kanu was notified on Friday, the 10th day of January 2025, that all appeals slated for hearing between 13th to 16th January 2025 are adjourned until dates are communicated to parties. But then, the Court of Appeal currently sits and delivers judgment, even as I speak. Today, Mazi Nnamdi Kanu has challenged the federal government of Nigeria to reassign the case to any other judge other than GFM Nyako and discover, if they were not aware in the first instance, how frivolous the counts of charges are. They cannot secure conviction of Nnamdi Kanu as it stands. Hence, their insistence on Justice Nyako, where justice would be slaughtered in their favor. In pursuit of their decision to frustrate the hearing of the cases on the merit and unlawfully keep Mazi Nnamdi Kanu in detention, the federal government today runs away from their own courts. Mazi Nnamdi Kanu is not only innocent of the charges leveled against him, he also has no case to answer. Hence, after 4 months of the order of Justice Nyako recusing herself and the case file remitted to the chief judge for reassignment, no such reassignment is done, and no date is communicated to the parties for the commencement of hearing or trial before any judge. What really is federal government afraid of? Your guess is as good as ours. Mazi Nnamdi Kanu is justified in asking that Justice Binta be recused from his trial. So we are now going to know why did Nnamdi Kanu say that Binta should not hear his case any longer. In spite of the decisions of the Supreme Court that Mazi Nnamdi Kanu did not jump bail, and that the trial court wrongly revoked his bail, making the impartiality of the trial judge suspect, the legal team of Mazi Nnamdi Kanu applied for an order restoring the bail of Nnamdi Kanu only for the trial court to refuse the application, holding that the only option available to the legal team of Nnamdi Kanu is that of appeal. Do you expect Mazi Nnamdi Kanu to subject himself to a trial by a judge against whom the Supreme Court of Nigeria has found to be biased and who is not ready to change? It is in the light of the circumstances that Mazi Nnamdi Kanu has reasoned that he can only get justice by any other judge of the trial court other than Justice Binta. Of course, there is reasonable ground for the finding of bias against the judge by the Supreme Court, and Mazi Nnamdi Kanu, being a law-abiding citizen, will follow the decision of the Supreme Court of the land. His Lordship Binta Nyako is biased. Any defendant whose bail is revoked is only sent to prison and not to the SS detention facility. Once you are granted bail and you are allowed to have revoked your bail, the next place they should put you is the correctional center and not the SS. Now, gentlemen, law is what it is because of predictability and certainty. The law as it stands is that since Mazi Nnamdi Kanu is injudiciously held by the federal government to have jumped bail, he is only to be kept in prison custody called correctional center and never in the SS detention facility. That is what the Administration of Criminal Justice Act 2015 provides. But the trial court has turned the law upside down and decided against the provisions of the Administration of Criminal Justice Act that Nnamdi Kanu be detained in the SS, and has severally refused applications for the transfer of Mazi Nnamdi Kanu to a traditional prison, the purport that the SS facility is a place of safe custody. The trial judge did not tell the parties or explain how it came to the conclusion that the SS facility is a place of safe custody without hearing from the parties. This, no doubt, is evidence of cloistered justice, implying that the judge has other means of taking evidence from one side, from outside the four walls of the court, and patching up facts to fit a predetermined target. We challenge any person to find any statutory provision empowering the DSS to detain any person in his custody to make such statute public. Declaration of IPOB as a terrorist organization is an attempt at entrenchment and confinement of judicial legitimacy to marginalization of Igbos. Igbos have severally Igbos have on several occasions alleged that the Igbo ethnic nationalities are discriminated and marginalized by the federal government of Nigeria, and evidence of such marginalization knows no boundary. It is a species of discrimination. IPOB is an acronym for Indigenous People of Biafra and stands for the people of southeastern part of Nigeria. The primary focus of IPOB is self-determination, founded on the established marginalization of Igbo. There are several such ethnic agitations for self-determination and the likes. Among them are the Arewa Youth Forum, mainly of Hausa Fulani ethnic stock, Odua People's Congress, Yoruba stock, Mieti Allah, Hausa Fulani, the Niger Delta Avengers of Ijo stock, Fulani Hesman, mainly of Hausa stock. Internationally declared to be the fourth deadliest terrorist organization in the world. That's international declaration. Nigeria has not declared any of the ethnic groups as a terrorist organization, in spite of their murderous disposition. But Justice Kafarati, the then Chief Judge of the Federal High Court, in conjunction with the federal government of Nigeria, were quick to declare IPOB a terrorist organization and proscribe the association for nothing other than that they are of the southeastern part of Nigeria. So any person of Biafra extraction is now a terrorist. The implication is that some of us who are from the eastern part of Nigeria are by that declaration terrorists. Now, it is in recognition of the discrimination and marginalization of the Igbos in the prosecution of IPOB that Justice A.O. Ondovo of Enugu State High Court declared thus, that the practical application of the Terrorism Prevention Act and the executive administrative action of the respondents, which directly led to the prosecution of IPOB and this listing as a terrorist group, said IPOB being comprised of citizens of Nigeria of Igbo and Eastern Nigeria ethnic groups, professing the political opinion of self-determination, and the consequential arrest, detention, and prosecution of the applicant as member or leader of said IPOB is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental rights, not to be subjected to any disabilities or restrictions on the basis of his ethnicity, as enshrined and guaranteed under Section 42 of the Constitution of the Republic of Nigeria, and his fundamental rights as enshrined under Articles 2, 3, 19, and 20 of the African Charter on Human and People's Rights. Is this how Nigeria is to be run? Now, the prosecution relies exclusively on undue technicalities, inspired leaks, and undue influence. What we mean by inspired leak is, if I have a case with you and I finish, both of us will go home. But you have information from the court official. That leakage will inspire you into taking action. Now we take it. Throughout the period of mock trial before Justice Nyako of the Federal High Court and the Court of Appeal, no decision of the court touched on the merit of the case. There are unholy alliances between the prosecution and the judiciary, so that the Court of Appeal refused to hear appeals on the ground that the panel requires time to study the appeal, even when the panel would have 3 months to study, deliberate, and determine the fate of such appeals, only for the prosecution team to get hints from the appropriate quarters in court, to file motion on notice challenging the entirety of an appeal. And despite the robust submissions against the motion, the motion was granted. Of course, no judge overrules himself, and the legal team of Mazi Kanu was therefore held to have waived their right to complain against the incompetence of the said motion. Nobody gave us reason how we waived our rights. On the foregoing, it is our view that Mazi Kanu is undergoing persecution and safe state-sanctioned extrajudicial detention and not trial. Persecution is a terrible approach to the prosecution of cases. From the unending adjournments, the refusal to prosecute the case before any other judge other than Justice Benta, the compromises centered on ensuring that Mazi Kanu is never allowed access to his lawyers for the preparation of his defense, it becomes irresistible a conclusion that what Nnamdi Kanu is facing is persecution from the federal government of Nigeria and not normal prosecution permissible under the Criminal Justice Administration. This happened in Abacha against the state in 2002, where the Supreme Court held, and I quote, "All powers to settle issues between parties is vested in courts, and court must be vigilant that genuine cases and controversies are settled so that no accused person will be oppressed, either directly or indirectly, through acts of prosecution. If not, we shall have persecution in place of prosecution. It is for this reason that an accused person, despite the power to file indictment on an information, should not be indicted to face trial from the outset if it is clear that he should not face. That is where, then we expect that normal prosecution commences before another judge of the Federal High Court, who would be even in the hearing of the appeals. So that is where I stop. Thank you, gentlemen of the press.
You write your phone number. I have phone number of some.
Okay, I have your question. Then I'm gonna somebody who is like.
Yeah, good afternoon, gentlemen of the press. My name is Jude Ugwany a member.
January 16th, 2025. My name is Aloy Ijmako. I'm one of the counsels to Mazi Nnamdi Kanu, commonly referred to as a special counsel. I'm here with my colleagues. To my right is Barrister Nnemeka Ejiofor. To my left is Barrister Jude Ugwanye. And to my extreme right is Barrister Mandela Umeborok. The other lawyers are under assignments. Now, this press conference has a theme. The theme of the press conference is Mazi Nnamdi Kanu and the emasculation of justice in Nigeria. It's going to be a prepared speech, and here we go. The press statement is a dispassionate submission on the grayling case of Federal Republic of Nigeria versus Mazi Nnamdi Kanu. It is divided into 3 parts and several sub-parts, which will be discussed under an introduction, an analysis, and an executive summary. Now to the introduction. Mazi Nnamdi Kanu's case began in earnest on October 14, 2015, when he was arrested on his arrival in Lagos from his location in the UK. The reason for this arrest, as it was alleged at the time, was due to broadcast he made from his location in the UK, comprising basically of his demand for the restoration of Biafra. He was then charged with treasonable felonies and other minor offenses. But later in time, Mazi Nnamdi Kanu was granted bail twice by 2 different courts, but the government of Nigeria disobeyed or otherwise unlawfully parried the court orders, and it remained not obeyed. However, much later, in April 2017, Mazi Nnamdi Kanu was eventually released on bail. Such was the case that on 16 December 2016, when the federal government withdrew all the charges filed against Mazi Nnamdi Kanu before the Chief Magistrate Court in Abuja, leading to the charges being dismissed also, and Mazi Nnamdi Kanu being thereby discharged. It will be recalled that these charges also were at that time dismissed. But the federal government doubled back and charged him back before the Federal High Court at this time. Beyond continuing to detain Mazi Nnamdi Kanu in disobedience of court order at that time, to the contrary, the federal government also did the unthinkable by arresting Justice Adeniyi Ademola, who had ordered unconditional release of Nnamdi Kanu at that time. According to several newspaper reports of 15th October 2016, Justice Ademola had stated, and I quote, "From the time of my arrival at the DSS office at about 6:45 p.m. on 8/10/2016, I was not told what my crime was for over 24 hours, till the evening of 9/10/2016. A DSS officer officially finally informed me that the search of my arrest, that the reason for my arrest was based on these 3 allegations. 1, petition of Hon Jenkins Duvie, dated 4th of April 2016 to the National Judicial Council. And 2, granting bail on Sambo Dasuki. And 3, the unconditional release of Mazi Nnamdi Kanu. This was perhaps one of the earliest telltale signs that Mazi Kanu was in for a rough ride with the darkest side of the Nigerian criminal justice system. Consequent upon his grant of bail in April 2017, he proceeded to his ancestral home in Afaruku, Ibek, Umuahia in Abia State. For someone enjoying his bail and awaiting his next court date, it therefore came as a surprise, deadly surprise indeed, that beginning from 10 September to 14 September, the Nigerian Army and other security agencies launched lethal military invasion of Mazi Nnamdi Kanu's ancestral home, where he was staying with his members of his family and well-wishers. It was indeed a deadly assault that claimed at least 28 innocent lives. Mazi Nnamdi Kanu and his parents, who were on location, sustained injuries, and his parents later succumbed to those injuries, and they are now deceased. Well, it is there, as they say, the rest is history, that Mazi Nnamdi Kanu, in order to save his life, had to depart the territory of Nigeria in search of a safe haven overseas. You will also recall that sequel to this attack, Nigerian army did not let off. They announced a nationwide manhunt for Mazi Nnamdi Kanu. And the immediate aftermath of that invasion, infamous invasion, Nigerian government promptly commenced a constitutionally questionable administrative action to proscribe IPOB and declare it a terrorist group. This decision was preceded by the infamous public declaration made by the Southeast governors on 17 September 2017. And accordingly, following these public declarations by our government officials, on 20th September 2017, late Justice Kafrati of the Federal High Court granted the federal government her wish in an ex parte application brought before the justice by the former Attorney General of the Federation, Abubakar Malami, SHÄM. Apparently, in taking the decision to proscribe IPOB and declare it a terrorist group, neither the Southeast governors who fired the first salvo, nor the federal government had recourse to Section 42 of the Nigerian Constitution, which is a fundamental right, a section guaranteeing the fundamental right of every Nigerian against discrimination based on ethnicity. I'm saying this because later in time this matter went to court, and the High Court of Enugu State, in a landmark ruling, pronounced the executive action or administrative action leading to that prescription as violative of Section 42 of the Constitution based on some ethnic considerations against the Igbo. Thus, by the plain provisions of that section, members of IPOB who largely hail from the Igbo tribe were generally criminalized. So to be clear, the practical application of any law enforced in Nigeria, including the Terrorism Prevention and Prohibition Act, or any criminal justice statute or legislation, has to be applied even-handedly across the board to all Nigerians without discrimination of any sort. But in this very instance, IPOB, having been perceived as springing from the Igbo and their cousins in the southeastern part of Nigeria, was singled out for the special act of discriminatory proscription and declaring it a terrorist group. Of course, this gave the federal government the legal license to direct its armed forces to resort to the rules of engagement, which required it to shoot to kill, not even shoot to maim anybody perceived to be a member of IPOB, and this has continued to this day. And of course, that was what culminated in the extraordinary rendition of Mazi Nnamdi Kanu from Kenya to Nigeria in 2021. It therefore follows that by failing to take action to proscribe other similarly related ethnic organizations, such as the Fulani Headsmen or Mietiala, or Odua People's Congress or Niger Delta Avengers, some of which are known to have borne arms and carried out violent attacks, but the federal government did not as much proscribe them or declare them terrorists as it did IPOB. It is our position, and which was confirmed by the court judgment I referenced, that the proscription was highly discriminatory. Now, in summary, the right guaranteed under that section is unarguably and essentially a right to freedom from any discrimination of any sort based on national origin or ethnicity, such as has been levied against the IPOB and its members, perceived or real, by the federal government since October 2017. The declarations made by the court are 3, and the orders issued 2. The court declared that action unconstitutional it also declared that what IPOB is engaged in, the enterprise, is known as self-determination and that it is not unlawful. And the court, because the action offended its conscience, awarded $8 billion against the federal government for that action. It therefore came as a double whammy that in the next few days following the proceeding of IPOB, the Attorney General of the Federation underscored the constitutionally prohibited finality of the action by gazetting it, and therefore criminalizing millions of Igbos who are perceived to be members of IPOB, whether the perception is real or not. And it also led to interdiction of their properties, money, and otherwise wherever found. It's also led to mass arrests, extrajudicial killings, torture, detentions without trial, and whatnot. Now, in March 2018, the African Union, through its African Commission on Human and People's Rights, which administers human rights adjudications in the continent of Africa, held against the federal government that the proscription was wrong under the African Charter, which bound Nigeria. Nigeria ratified the African Charter in 1983, and from that date it is bound by it. So this African Commission on Human and People's Rights had clear jurisdictions to decide this case, and it decided against the federal government,